Okay. So, hello, my name is Sasha Struthers. I am an attorney here in Los Angeles, and I do landlord-tenant cases, specifically habitability cases, discrimination cases, and tenant buyouts. And today I brought on Andy Baker, who's also an attorney here in Los Angeles, and he does a lot of code enforcement cases. He's been doing code enforcement for over 12 years. And we brainstormed and got together and thought it would be really helpful for landlords in LA to do a video about REAP, which is the Rent Escrow Account Program, which I sometimes refer to as like landlord prison. But we are going to do a video today about REAP, what REAP is, how you get into REAP, and some of the things that Andy has learned over the number of years that he's been dealing with code enforcement cases and REAP. About REAP and kind of the trends and what he sees going on and how the city is handling these cases. So to just jump right in, hi, Andy, how are you?
Fine. Thank you, Sasha.
You're welcome. So for people who, a lot of people know about REAP if you're, a property manager or you're an institutional landlord, but let's pretend I'm a mom and pop landlord. I got a REAP and REAP notice or, the general manager hearing. Actually, I'm not even gonna get into it. I'll let you explain kind of the steps of what REAP is and how one gets into REAP. So I'll turn it over to you.
Okay, REAP is, as you mentioned, the Rent Escrow Account Program. It's administered by the Los Angeles Housing Department, which has jurisdiction over all the apartments, duplexes, multiple units in the city, and townhouses built after October 1st, 1978. The Rent Escrow Account Program is the Housing Department's way to maintain the integrity, if you will, of
I hate when that happens. I got kicked out. I don't know if the editors are going to fix this, but okay. Taking it back from the top. CJ, I don't know how you're going to fix this. I'm so sorry, but the internet kicked out. So we were talking about REAP, which is the real estate, the rent, there's too many acronyms, the Rent Escrow Account Program. Okay. Go.
The Rent Escrow Account Program is a incentive, if you will, for apartment owners to maintain their property. Because if they don't maintain it, what happens is there's what's called a systematic code enforcement program by the Housing Department, where every 3 to 4 years they will inspect every apartment building in the city, and they will inspect the units as well. And if you're not in compliance, they will cite you. They'll cite you for things like fire safeties, no batteries and smoke detectors, batteries in and the detector's not working. If there's a big enough building for fire safety issues, maintenance, do the drawers all work? Do the cabinets all work? Does the plumbing all work? Are there leaks under the sink or in the bathroom? Is there illegal construction? Is there unapproved occupancy, et cetera, et cetera? And if you get cited for most of those things, everything except for unpermitted occupancy or unpermitted use, they can put you into the Rent Escrow Account Program. The way it's done is through a general manager's meeting, which is an administrative hearing for the owner. The owner gets cited. They have a certain amount of time to bring the property into compliance, which is an artificial timeline and usually impossible to comply with. But there'll be an administrative hearing where they'll hear from the owner or the property manager, or if you're smart, the owner's attorney, and whoever it is on behalf of the owner will explain why things have been fixed, why they haven't been fixed. If they haven't been fixed and you don't have proper representation, they'll put you into the rent escrow account program.
Okay. So I've dealt or on the brink of a rape case and it got all the way to a hearing. But everything was fixed by then. So that was kind of a non-issue. But going back to rape, so it starts out with either a complaint that's filed maybe by a tenant or the SCEP, which is every 3 to 4 years. They do an inspection and they give you out a report of things to get done. How long after getting that like initial order to comply do you tend to have until it goes to a general manager's hearing? Like how do you get to that hearing?
There's some number that they specify. I can't recall it offhand, but it's usually 3 to 6 months later. They'll send you a notice of the general manager's meeting, which is that administrative hearing.
And what is it that you typically see as the most common reason why landlords get into rape? What kind of violations are they committing?
Well, they run the gamut, but fire safety, the smoke detectors is a big one. If there's fire doors, if the building's big enough, the fire doors have to close, should be closed. That's a big one. The doors, period. The doors to every unit have to be self-closing. The flooring has to be even. The plumbing has to work. The doors and windows have to open and close without obstruction. The can't be junk and a bunch of merchandise of any kind on driveways. There has to be clear access to garages and parking spaces. Just about anything you can think of goes into it. They also have illegal construction, which tends to be a problem because a lot of landlords will, particularly now with the accessory dwelling unit laws changing, will try and make extra units out of spaces that were not designed for or to be legal for another dwelling unit, and they'll do it without pulling permits. In fact, just about everything I said, a lot of it requires permits. What they used to do was they used to cite unpermitted units as illegal construction. Either the citing inspector has changed that, or the sitting inspector at the hearings will note that this was should have been written up as unapproved use or unapproved occupancy. If it's one of those two, those are not reapable offenses. So that's why you need to have somebody who knows what they're doing at these administrative hearings. But it's all things related to trash. Your trash has to be neatly put away. It's everything that you can think of. If there's a hole in your stucco, if the drain spouts aren't working, everything is designed for the tenant. It used to be all designed against the landlord, but nowadays they're working with the landlord. But it's maintenance items and it's upkeep, and you mentioned, Sasha, it's habitability issues. There's certain codes that we're familiar with about what's a habitable unit and what isn't. A lot of it's common sense, but some of it's pretty sticky. So it's the Los Angeles Housing Department's way of maintaining the stock of apartment buildings so everything is habitable for the tenants.
And have you had any cases where, for instance, you talked about not having stuff in the driveway or in the garages? I know a lot of landlords struggle with the balance of, tenants having their stuff in like common areas, and it kind of piling up and tenants just not moving it out. Have you had any cases dealing with that specifically, where it seems to be the tenants not cooperating with the landlord?
It happens a lot. Particularly happens on the smoke detectors. I don't know why, but tenants are always disconnecting those. And, there's supposed to be a segregation between the common area, which is open, of course, to everyone, but the landlord's responsible to maintain, versus the units themselves. And a lot of times the tenants simply won't cooperate. There's any number of stories, I'm sure either of us could tell about that. But yeah, that's a big problem for sure.
I'll do my 2 cents. I haven't done as much of the legal side of the code enforcement dealing with these cases, but I've done a number of SCEP inspections, walking them with the SCEP inspector as a property manager or representing the landlord. And that's some of the things that they even told me, they go, hey, if you can fix the battery, change it. If it works, you'll be fine by the time I leave here. So they do try to cooperate with landlords, but that's like the number one thing. And the inspectors will tell you, they go, we don't get it, but tenants always disconnect the smoke detectors. And I think it has to do, a lot of them now, there's combos, and they're combo carbon monoxide and smoke, and they have batteries. And if you don't change the battery, sorry, I'm out of focus. Okay. If you don't change the battery, it beeps. And tenants just will not change the battery. I don't know, or they'll disconnect the whole module and they'll just like lose it. They'll put it down somewhere and they'll lose it. So I've seen that like quite a bit. And typically with like, with landlords that are property managers, or they have, quite a few units under their belt, they have a handyman that tends to go to the inspection and will be able to kind of address those on the fly. Like they'll have extra ones ready to go. You pop them back in and it kind of appeases it. But the one thing that I have the HUD, which is the Section 8 inspection report. HUD has published that. So when you get like a Section 8 tenant and they do the initial inspection, I've seen kind of what they check for. But I haven't, and maybe you've seen it, but I haven't seen like a SCEP checklist of like, what you can send, like to step back a few. When you do this, like, 3-4 year inspection of the property, you tend to get a notice a few months out, and they post it on the property and they mail it to the landlord. And they say, at this date, we're coming and we're going to inspect your property. So a lot of landlords do is they send typically the handyman out. Okay, go check all the units and make sure everything looks okay. But that's one thing I haven't been able to find, is like the checklist of like what they're typically looking for. Cause they come in with like their tablets and they like just check everything off. But I don't know, have you ever seen some sort of like LEHD checklist of like, this is what we're looking for when we do a SCEP inspection?
No. And the reason they don't do that is because they're pro-tenant, they're not pro-landlord.
Yeah. I anticipated that. I see there's a lot of resources. I think they're trying to be better about it, but there definitely is a lot more resources about tenants and how they can pursue their rights. But there's not enough, to me, information about how landlords can,
And you're back.
at least you got the answer out before it paused this time. Okay. So another thing that I'm curious about is there was really, really strong punishments for illegal construction, which typically was illegal garage conversions. It was the most common one I've seen, either usually I'm like the least important part of this whole video, apparently. I think if you're like doesn't need me.
You should really pay your bill on time.
I know, my God, Spectrum. Talk about monopoly. Okay, I'm going to restart that. So another very common thing that you talked about earlier, which is illegal constructions, which I've seen a lot are garage conversions, typically detached garages in the back that, you know, people will make like a unit with good intentions to start. But what's the pattern you see with the city addressing these garage conversions while simultaneously pushing garage conversions?
That's an interesting issue because the mayor, whoever the mayor is right now, Karen Bass, and the council are promoting more housing. The state is proposing more housing through the accessory dwelling units. But in practice, the city agencies aren't quite so accepting, particularly the housing department and the building department. The housing department basically passes the buck and says, get your permits and deal with the building department. And once you get the permits, let us know and we'll re-inspect it. The owners, particularly since COVID, who have gotten just, you know, brutalized by that, the decisions made by the city government, are often forced to look for other ways to increase their income. So they'll try and create accessory dwelling units. Sometimes they'll follow the law. Most of the time, in my experience, they don't. And they don't get it permitted. And they'll try and they'll use a balcony to add a unit. I was out at a property a couple days ago where there was a basement recreation room, and on the permits it does say recreation room, but when you did an investigative research, it turned out that the rec room wasn't a habitable building space. So what happens is landlords are trying to create extra revenue. They're making these extra units, and it just depends how. No two inspectors cite things the same way. Some of them will cite it as illegal construction. Some will say illegal use and occupancy. And as I've mentioned, if it's illegal construction, that's an offense that you can put the property, they can put the property into REAP over. So it makes a difference. You know, what I find, it's very helpful for owners to talk to lawyers like ourselves who work in this area. I was a real estate and construction lawyer before I got into this area, and it just dovetailed into what I was doing anyways. But you really need to talk to people who are knowledgeable about what you can do, what you can't do, what's it going to cost, what if you don't do something, what if you do something, how they cite you, what should you do. All those things go into the mix. So I hope that answered the question, but I don't know.
What I've seen is, you know, at the permitting process, so you can do an illegal garage conversion and then you can try to permit that, but it tends to be a very long, drawn out process. In the meantime, you have this person or, you know, people, these tenants in this unit that they have to move. Relocation comes into play. You need a government order. And that was all very complicated by COVID because they, you know, paused all these evictions. They were code enforcing, but they weren't code enforcing. They were, you know, they were doing this or doing that. So I find it interesting. A lot of people were doing garage conversions. Typically, I've seen it to help out friends or very close family. And sometimes they cooperate. A lot of the times they don't. And so that also has, you know, not only, you know, do you end up potentially in REAP or end up in REAP, but then it creates a litigation issue because then you have tenant attorneys that are like, right there ready to sue you. Not only are you in REAP and in trouble, you have an order to comply against you, but then you have an attorney who wants damages, who wants relocation, who wants this, that, the other. So it's definitely, it's now that we're pushing this ADU thing, it's kind of conflicting. But it just goes to show, like, if you're going to do anything, you probably should do it by the books and, start with the permitting process. Though to somewhat come to the defense of landlords, I know a lot of times these garage conversions come from trying to help people who can't afford housing, family members that, come here, don't really have anywhere to go. Family members are down and out, friends. So that's kind of, I think, the one bummer about it is that I think the intention there is, yeah, I'm going to make some extra income, but it's typically they know who's in that unit and then they know who's in that garage, so to speak. So that's from what I deal a lot with, which is the litigation side of it and having, these illegal units. That's, something that I find very interesting that they don't want to address or doesn't seem to get addressed. So both agencies tend to ping pong with one another, like you were talking about earlier, where housing and LADBS both don't want to be the bad guy in it, but they're both equally bad guys. Probably the building department more so because it's so hard to get permits. So that being said, what is some of the things that you learned in dealing with code enforcement cases that you found would be helpful for a landlord to know to, as best as possible, avoid getting into REAP?
The most important thing is not to procrastinate, but to jump on the violations as soon as possible. There's a little caveat here, which is a lot of it depends on who the inspector is. Inspectors from any department in the city basically have unfettered discretion to do what they want. And you're not going to get two inspectors citing the same offenses. And let's say something as simple as caulking, they'll say you got to caulk the sink in 12 apartments. You would think that'd be a simple matter of caulking the sink, but if you get into REAP, they're going to look at everything with a fine-tooth comb. So you want to avoid going into REAP at all costs, because we'll explain there's also financial costs related to it. But the most important thing to me is to jump on those issues. You either talk to someone like us who have dealt with these things, you as actually both of us as property managers.
You want to avoid going to REAP at all costs.
Because both of us have been property managers and we understand what it takes to maintain a building. And you want to talk to either someone like ourselves or other construction experts who can tell you, you need to fix this, you need to fix that. And let's face it, a lot of these things are expensive, but the more items you can address and fix, then the better off you're going to be, because when you do get into that administrative hearing, you or your representative is going to be able to go down the list. Here's what we did. We fixed these windows. We fixed these doors. We fixed these floors. We fixed the smoke detectors, and so on and so forth. All that's going to be to your advantage in those hearings. And because it's oftentimes difficult, if not impossible, to comply within the time frames that they give you, a lot of times you can buy yourself more time.
And another thing for that, if you're preparing or you anticipate that you're going to get to this hearing, but you're diligently working at making the repairs, it's really good to take photos of the stuff that you've done and keep records. Either it's the invoices or the bids from the subcontractors that you've hired, or, you know, the Home Depot, Lowe's receipts for the supplies that you've bought, having all of those. I remember sitting in an eviction case, and the tenant, you know, said, hey, you know, as a defense, habitability. And I remember the judge saying, hey, that's not a really strong argument. Your landlord has really good maintenance logs. And that like really sat with me, because the maintenance log is really, really important regardless. And I know it's the most tedious part. I'm out of focus. It's the most tedious, one of the most tedious parts with property management is to keep track of the maintenance. So I always, you know, there's different ways to do it. Definitely keeping together, like if you have a handyman, keeping track of their hours, where they're at, what they're doing, if they have receipts, you know, if they have some sort of expense card, keeping that together. And, you know, as much as you can do chronological, like, hey, this was done on this day, here's the photo where it's fixed. Because when they do those SCEP inspections initially, or they do, you know, sometimes complaints initially, and they walk the unit, they take photos of everything. So they know what it looked like. And if you can have photos and say, hey, I fixed it. Some inspectors will say, hey, email me the photos and I'll keep them. Some will just say, keep the photos yourself and, you know, just keep track of it. But the stronger and more organized your case is at those hearings, you know, it's definitely not going to hurt you. And trying to, you know, convince housing to not put you in REAP or to close out your case.
Right. Absolutely.
Well, is there any, I think we covered a good chunk of REAP. I don't think there's, it's a very scary thing, but it's also a very simple topic, in the sense that, like, if you don't maintain things, you eventually get to this hearing. Is there any, go ahead.
I'd like to say one other thing about REAP, which is once you're in REAP, the tenants have a choice. They can either pay into the escrow account or they can pay you. That's actually the second thing. The first thing is the housing department's going to dock the rent. They're, depending on the severity of the violation, it could be anywhere from 10 to 40% that they're going to knock off. So you're never going to get that rent, that portion of it back. It's only while your property's in REAP that applies. They also, the housing department will charge you a monthly fee. They'll charge you every time they come out to inspect. And the only way you can get the rent escrow account money is to apply it to whatever violations were charged against your property. But sometimes, like, you might have a illegal construction and you don't have the money to fix that problem, then all the money's getting pissed away through the rent escrow account program, and you've got nothing to show for it. So it's really, really important to jump on any of those violations, get them cured as soon as possible. If you have any questions, call Sasha, call me, but you know, jump on it.
Yes, I think that, I'm glad that you brought that up. I know we've talked about, you know, what REAP actually looks like. I'm glad that you jumped in and said that. But overall, from, you know, a landlord perspective, whether you're a small landlord or an institution or a property management company, every landlord is very susceptible to being into this, and every landlord is held to the same standard, more or less. So while it does deeply impact We're doing so good. I was doing so great. I'm going to redo that. So thank you for jumping in and adding the part about the REAP and the actual effects of it, which is not being able to get your rent money, and the city essentially somewhat holding it hostage while you repair stuff. It's really, really important that I like to stress this to all landlords when I deal with them. A lot of landlords, and I dealt with this when I was doing employer defense, there's no such thing as ignorance of the law. So if you're a small landlord or you're, you know, a huge institutional landlord, all of the rules will apply to you, and it's going to be more devastating most likely to smaller mom and pop landlords than to bigger ones, because they tend to be able to absorb it probably through other properties. So it's really important for landlords to a few things: check the property. You know, I like to say quarterly. I know it's really hard if you're not local, but if you're not local, you can have a property manager, but check it quarterly. Just do a walk. Really, really enforce your lease if you have provisions about, you know, tenant upkeep or them not having stuff in common areas. It's really important that you enforce those things, because those things, if you get busted for them, even if it's maybe the tenant's fault, you're going to be held responsible for it. And whenever a tenant has a maintenance request, irrespective of SCEP or them filing a complaint with the city, really, really act diligently on getting to maintenance requests as soon as possible, and don't sit on them. Don't wait on them. Deferred maintenance is like another killer for landlords, because a lot of stuff that you get cited for can potentially be just really, really deferred maintenance. So those are my concluding thoughts, and at least dealing with REAP. So again, thank you, Andy, for coming on. I really appreciate you taking the time to talk with me about REAP, and I will leave Andy's information in the description box. So if you want to reach out to him, you can reach out to him. If you want to reach out to me, you can find me, you know how to find me. And I hope this video was really helpful. If it was, I was told I was supposed to say this: you have to like and subscribe, because I'm going to have a lot more of this content. And additionally, leave comments if there's other kind of videos that you want to talk about. If there's other people that you think would be interesting for me to interview. And I would be more than glad to get that ball rolling on other videos. So thank you.